Hey everyone, it's Kristen Mackintosh, the happy lawyer here at Schweitzer and Associates, and putting on our January webinar for this year, starting off the year with walking through the winter wonderland of estate planning, how to avoid estate planning mistakes. But first, a little bit about me. I am the happy lawyer. Yay! Because I love what I do, which is helping my clients plan their estates, making sure that they are protected and that their family members are also protected. I'm also, in addition to estate planning, I like to bake. So my clients get homemade goodies. That's just a little tidbit about me. So now on to the main event. We're going to go over some common estate planning mistakes. These are mistakes that some of my clients, before they became my clients, have made, and that other people in talking to them have made. And I want to make sure that none of you make these mistakes, because none of you are going to do it, right? Because you're going to pay very close attention to this webinar.
Mistake after mistake.
Yeah, we don't want to have mistake after mistake. So the first mistake that I often see is people don't understand how their assets will pass upon their death.
You don't understand.
And why is that important? Well, a lot of people just assume that their will, if they have a will, is going to control all of their assets. It's going to control everything that you own, and it's going to control to whom your assets will pass to when you die. But that's not necessarily true. Because you see, beneficiary designations will always trump the will. Now, most of us have our wealth, accumulated in things such as our investment accounts, our IRAs, our 401ks, our life insurance plans, and our retirement accounts. And all of those have beneficiary designations that you can make, and you should have beneficiaries on all of those. So make sure you check those items to make sure you do have beneficiaries. But you have to understand that those beneficiary designations are going to trump anything that you have in your will. So we're going to look at the story of Frosty the Snowman and kind of illustrate what can happen in this scenario. Here's little Frosty. Now, before Frosty got married to Crystal, he didn't have, a wife at the time. And so he made his friend Karen the beneficiary on his life insurance and on his investments. Well, Frosty then, as we all know, met Crystal. They got married, and Frosty did change his will. And in his will, Frosty stated that everything was to be left to Crystal. Unfortunately, Frosty forgot about his beneficiary designations. So when he died, poor Frosty, the majority of his wealth went to Karen and not to his wife, Crystal. Now, that's not what Frosty intended, but because the beneficiary was listed Karen was listed as the beneficiary, she was the sole heir of those assets. So poor Crystal basically got nothing except for Frosty's hat. Granted, it was a magical hat, but I'm sure she would have preferred to have the money. So just keep in mind, make sure your beneficiary designations match what your intentions are in your will. The next mistake that I see people making is they like to add their children to their house deed. Now, granted, there are reasons why you may want to do this when it comes to Medicaid planning. However, you have to be cautious when you're adding a child to your house deed. And we're going to look into why that is.
Gain? What would I gain?
Well, there's a lot that you're going to gain and your children could potentially gain. First, there is the gift tax. If you put your children on the deed, the federal government allows a gift tax exemption every year of $16,000. It used to be $15,000. This year, they've raised it to $16,000. So anything above that, that is, based on the value of your house, is going to subject you to having to file a gift tax and then of course your child is going to have to pay, or you as the grantor, the owner of the home, are going to have to pay the taxes on that gift that you gave to your child. So if you make your child a joint tenant on your house, then your child will be subject, the gift tax will kick in at the, sorry, the full value of the house. So that could be a huge penalty. Also, when your child, excuse me, when your child is on your house, they become a co-owner with you, which means that if your child gets divorced, or your child ends up getting sued or has creditors, those creditors and that ex-wife can attach to the house. So now you're not just owning the house with your child, you now have a lien on that house from the creditors, or you may be owning the house with the ex-spouse. Not a good idea. Capital gains is another thing you want to keep in mind. What do I mean by that? When you own a house and you sell your house, you are allowed an exemption on capital gains up to $250,000. Your child, because you added him or her to the house, is not going to get that same advantage. So they are going, when the house is sold, although you're going to have it taxed, not have any, be subject to any capital gains, your child is going to be subject to capital gains. And it's going to be based on not at the time that you gave them the house, put them on the deed, but it's going to be valued at the time that you purchased your house. So in today's market, where homes are selling for hundreds and thousands of dollars above market value, that could be a huge tax consequence. So you want to be very careful when you're thinking about putting your child on the deed. It's better to just gift the home to your child through your will, because that way your child receives the stepped up basis. In other words, the capital gains or capital losses will be based on the value of the home at the time that you die.
Bad idea, bad idea.
So bad idea, putting your kids on your deed for the most part. And if you're considering doing that, you definitely want to talk to an estate attorney as well as an accountant to see if the costs are going to outweigh the benefits. The next mistake we have is failure to provide for problem children.
Bad to the bone.
Now, our children are not bad for the most part. What I'm talking about here is your child may have a problem. They may have a gambling problem. They may have an alcohol problem. They're addicted to drugs, or they just like to spend money. And let's face it, when those children come into a sizable inheritance, what's going to happen, folks?
Here comes the money, 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 money.
Dollar, dollar.
Yep, those children are going to take that money, and most likely they're going to spend it in order to satisfy their bad habits. Because once you give somebody something through your will, you can't control it. I tell my clients, you cannot control from beyond the grave unless you put the money in a trust. Now, the way around that, if you have a problem child or children, you can put the money in a testamentary trust, which is a trust that's created through your will when you die, or you can create an actual revocable trust that goes, that'll control the money for your children. And the advantage of putting that money into the trust for your child is that you can set an age limit for when your child can come into their inheritance. You can, put stipulations in there that they have to pass drug test or alcohol sobriety test. You can put limitations on how the trustee can distribute the funds to your child. So it's just, if you have a problem child, you definitely do not want to give them the money outright. Oops. Then I just skipped a slide. The next one that we see is a failure to protect a disabled beneficiary. Now, what do I mean by that? A disabled beneficiary is somebody who perhaps is mentally handicapped, or maybe they're physically handicapped, or they had a stroke, they're in a nursing home, and they're on Medicaid. These are all red flags when you are creating your estate plan. The red flags in the fact that if you're not careful, and you just leave them the money outright, then those people can lose their government benefits, because government benefits such as Medicaid are based on need. You have to have below $2,000 in income. So obviously, if you were to give your child, make your child a beneficiary through your will, they're probably going to be inheriting more than $2,000, and that can kick them out of their Medicaid assistance. And we don't want that to happen. So you can some people say, well, okay, I'll protect my child and I won't give them the money outright, but I'll give it to their sibling. And the sibling, we have an understanding that he or she will use the money to, pay for my child's, non-medical needs. Well, a couple of problems with that. One, again, can't control beyond the grave. So once you give that other child, leave them all of your money, then it's theirs to do what they want. So they don't have to take care of their sibling, even though they might have promised you they were going to do so. So one way around that, if you have a disabled person whom you want to make a beneficiary under your will, is we set up, again, another testamentary trust. And this time it's a special needs trust, sometimes called a supplemental needs trust. This is a trust where the money, your inheritance, pours into that trust, and the trust specifically states that it cannot be used, the funds cannot be used for anything related to medical care. There's also a provision in there that if Medicaid or some other governmental program were to deem the special needs trust assets as what's called countable resources and would kick them out of the program, the provision in the trust allows that trust to be dissolved, and then the money goes out of the trust and on to your other heirs. So you definitely want to consider having a special needs trust either in your will or separate if you have a special needs person in your life that you want to leave benefits, because otherwise, by not doing so, you're going to jeopardize the Medicaid benefits.
Oops.
We don't want to do that. So another mistake I see people making is they think they can just write their own will. Now, if you want to do that, there's nothing stopping you, but there are some problems you have. I mean,
Shame.
no one's going to shame you for writing your own will. But the problems that arise when you write your own will are, one, you may have bad handwriting. Raise your hand if you're like me and you have bad handwriting. Okay, I'll admit it. I have horrible handwriting. Sometimes I can't even read my own handwriting. Well, let's say if you're like me and you have that bad handwriting and you go and you write your will, and then when you die, no one can read your will because they can't decipher your handwriting, then it's going to be like you died without having a will in place. And then you leave it up to the state to determine who's going to inherit from you, and that's not necessarily going to be whom you had wanted to inherit from you. And additionally, you may lose out on some tax savings advantages that an estate planning attorney can give you. Now, right now, the federal estate planning tax is so high for a single person. It's a little under $13 million, which most people, I would wager, are not in that category. But let's say the federal estate tax drops down to more like, $500,000. Well, when you throw in your home and your investments, that could affect a lot more people. So an experienced estate planning attorney can help you tweak your estate plan where you can legally pass assets. Again, I stress the word legally, pass assets on to your heirs in distributions that will either minimize or prevent any federal estate tax from kicking in. Also, a danger of writing your own will is your intent is not always clear. Wording is very important. And when an estate planning attorney will take the care to make sure that the words actually express your intent, that there's no confusion as to what you actually meant. Now, I just want to show you an example of bad handwriting in a will. This is,
Oh, I can't even read that.
can anybody read that? Can you make that out? This is an actual will of a famous celebrity who we're not going to mention here, who did this handwriting will, and it's kind of confusing. It's like, I don't know, there's crossed out here, there's words over here. I mean, I can't make out what she was saying, and neither could her estate planning attorneys and the probate court. So it ended up resulting in a very long, protracted court battle. So don't do this. See an attorney, have your attorney do your estate plan. It's worth the money. Next, we have the failure to fund your living trust. I don't know. A lot of people come into me and they say, I want to create a trust because I want to keep my assets out of probate. And I'm like, great. So we'll prepare this trust, and I remind them, you've got to make sure you fund the trust while you're still alive. Now, we always have a pour over will that's a catch-all, has a catch-all provision that states that anything that is not in the name of the trust at the time that you die will pour into the trust. But those assets are going to have to go through probate. And people walk out of my office and they're like, okay, yeah, I'll get it funded on here. Now, some people do intentionally choose not to fund their living trust during their lifetime, and that's okay. You just have to understand that if you don't fund your living trust during your lifetime, then your assets are going to go through probate. And probate is a public record. And when I say probate, that means going through the court. You have to actually file with the court a list of all the assets that you owned in your name at the time that you died, as well as the value of those assets. You also have to file your will. Now, technically, because it's filed with the court, it is public record. Anybody can go to the court, pull the will, pull your estate probate file, and they can see everything you wrote. Will somebody do that? Probably not. But if you're concerned, and some people do have concerns, some people want to treat a child differently than their other children, and they don't want the child who's being treated differently to know that. So they've put a provision to that effect in their trust. And keep in mind, a trust beneficiary can only see what he or she is entitled to. They don't get to see the rest of the trust. So if you fail to title your assets in the name of the trust, and you were trying to avoid that ugly issue, guess what? You may have a family dispute on your hand, and that's just not a good idea. And there's also an expense because, of course, there's no federal estate tax. The federal estate tax is so high, most people aren't going to pay it right now. North Carolina does not have a state estate tax, but the probate court, they're going to have their cost. Here in North Carolina, the courts charge 40 cents for every $100 of assets that belong to the estate. You also have to pay court filing cost. Well, you got to file a cost to open the estate. You've got to file a cost every time you file your 90-day inventory, your accounting, etc. And that can all add up pretty quickly. And not to mention, if you have to hire a probate attorney or an estate administration attorney, that can be very expensive. So if you're going to do a trust, make sure that you fund it with most, if not all, of your assets during your lifetime. Next, we have the issue of divorce. Unfortunately, they say statistics have always been 50% of marriages end in divorce.
Divorced, separated, divorced.
And while most people are pretty good, or at least their family law divorce attorneys remind them to change their wills after they get divorced, people don't think about changing their estate plan while your divorce is pending. Why is that an important factor to consider? Well, usually most divorces are pretty cantankerous and spouses get angry and they don't like one another. And I don't know about you, but I don't want someone who's angry with me going to make the decision as to whether or not my life support should be terminated. Okay, so when you're going through a divorce, while you're separated here in North Carolina, you have to separate and live apart for a year. You definitely want to change your estate plan and appoint somebody who is not your spouse to make those decisions for you. Now, if you reconcile with your spouse, that's great. You can always, again, change your will and your estate planning documents, your power of attorneys to make that the reconciled spouse, again, your agent or your executor or your heir. But play it on the safe side, folks. And if you're going through a divorce or planning on getting separated, you may want to meet with an estate planning attorney to change your estate plan. Now, is your spouse going to drown you? We hope not. But again, it just illustrates that sometimes, people have hard feelings. So make sure you get that ex-spouse or soon to be ex-spouse off of your estate plan. The next mistake I see is not having an estate plan at all. A lot of people are like, yeah, I don't need one. Well, the problem with that is it can be a little dangerous or hazardous not to have an estate plan. And why is that? Well, the number one reason people give me for not having an estate plan is like, you know what, I, don't really have a lot of assets, or, of course my spouse is going to inherit everything from me because we're sharing everything as a married couple. My family understands this. Well, the problem with that is if you don't have an estate plan already in place, most states, if not all, including North Carolina, have a nice little estate plan already set for you. It's called the Intestate Statute. Now, the Intestate Statute is basically, it follows the family tree. Here in North Carolina, if you don't have an estate plan, or if you do, but let's say you did it yourself and you have bad handwriting and they can't read it, then it's going to be treated as if you died without having a will. And then the person or persons who are going to inherit from you are going to be determined by the state of North Carolina. And the state doesn't care if you like those people. The state doesn't care if you haven't had contact with those people in a long time. If those people are in the chain of the statute, they are going to inherit from you. Now, as you can see from this chart, if you are single and you die without having any children, your estate will automatically go to your parents if they are still alive. And if they're not still alive, then it's going to pass on to your brothers and sisters. Now, if you die as a single person, but you do have children, everything will go to your children. So that's a relief. But if you are deceased, or when you die, if you're married and you don't have any children, let's see what happens here. Well, in North Carolina, if the parents are still living, the deceased person, if your parents are still living, they're going to get half of your estate and your spouse gets the other half. Not a good situation, folks. I actually have done some probate matters where this is the case. Now, luckily, I was able to get the parents to renounce their inheritance so that the spouse could inherit everything from their deceased spouse, but that's not always going to be the case. Now, if you're deceased, when you die, if you are married and you have children, we are going to bypass the parents in that scenario, but you're going to split the estate with your children. You're not going to get it all. Probably not a good situation.
Seems like a bad plan.
Seems like a bad plan to me too. So you want to make sure you have a will so that you can control who is going to inherit from you. Don't leave it up to the state, folks. Even if you look at this chart and say, oh, this perfectly makes sense, I'm okay with that, don't do it. Just get your will down. It's your life. You earn those assets. You need to be in control of those. And your will doesn't have to be very lengthy. Next, a lot of people forget about man's best friend. Now, what do I mean by that? Most of us have pets. More and more people are acquiring not just one pet, but more than one pet. And a lot of people don't stop to consider what's going to happen to my pet when I die. They just automatically assume that a family member is going to take care of that pet. Well, the reality is that may happen, but the reality is a lot of pets end up in shelters because nobody wants the dog, or there's fights. They're like, I can't take the dog, I can't take the cat, and or they just don't want another animal. And so they'll just put the poor dog into the shelter.
This is the pound, isn't it?
And this is your poor dog. Your dog doesn't understand, or your cat, or your lizard, your bird, whatever you happen to have, is not going to understand. They're already going to be grieving the loss of you, and now they're in the pound. Now, nothing against animal shelters and pounds. I know they serve their purpose, but if your pet has been living the pampered life, such as my dog Bailey, who goes to daycare, who wears sweaters when it's cold, who sleeps in my bed, who lays on the furniture, he would be traumatized if he had to go to a shelter. So what you want to do is you want to talk to your estate planning attorney about making a provision in your will as to who is going to care for your pet. Now, you can do that through by creating a formal pet trust where you actually appoint a trustee and maybe distribute some of your assets into that trust to be used for the care of your pet. You also would appoint a caretaker who would be the person responsible for, housing the pet, feeding your pet, making sure your pet, gets the meds if it's on medications. Or you can just make a provision, which a lot of my clients do, which is just, I give, for me, it would be, I give my dog Bailey to, my niece, Emily, to take care of. And if Emily's not able to take care of my dog, then my dog or any other pet that I have will go to, such and such person. And I always add a catch-all provision that if there's nobody available that I've named to take care of the pet, because either they've predeceased me or they live somewhere where they're not able to take care of a pet, or maybe they have a health problem, that we assign the executor the duty to find a caring, loving, suitable home. And we specifically state that the dog or cat is not to be placed in a shelter. So you definitely want to, if you're an animal lover like myself, you definitely want to think about including your pets in your estate planning. And a lot of people, the last mistake we're going to cover is a lot of people just limit their estate planning to a will. When they hear the words estate planning, they're like, oh, okay, it's a will. I've got a will done. No problem. I'm done. No, you're not done. The will is just the first step in an estate plan. Yes, you need to have a will on here. It's very important to do so, but the will only covers things that happen to you when you die. The will does not cover things that could happen to you during your lifetime. For instance, you could become disabled. You could have a heart attack or a stroke, or maybe you develop Alzheimer's or dementia. Well, now you're not able to make decisions on your behalf. So you need to have a power of attorney. There are two power of attorneys. One is called a durable power of attorney, also known as the financial power of attorney. This document is where you appoint somebody who will make financial decisions on your behalf should you become incapacitated. And it could be just that you're out of the country. You don't have to necessarily be disabled, but maybe you're out of the country and you can't access your bank accounts, but you forgot to pay a bill. Oops. And you're like, oh my gosh, what am I going to do? Well, if you got a power of attorney in place, you can reach out to your agent, and he or she, using that power of attorney document, can pay that bill for you. Shoo, crisis averted. The other type of power of attorney is called the healthcare power of attorney, otherwise known as an advance directive. This is a document where, unlike the durable power of attorney, your agent is a person of your choosing that you appoint to make medical decisions on your behalf. Now, worst case scenario, again, you may have Alzheimer's or dementia. But what if you're just in an accident and you're unconscious? Well, you can't tell the doctor what you want or authorize treatment for you. But if you have this advance directive in place, then your agent can speak up for you. Now, the advance directive slash healthcare power of attorney only goes into effect when you cannot communicate or understand your doctor. And the doctor, or rather the attending physician, is the one who makes that decision. So if he or she feels like you're not understanding, because maybe you have a concussion and you're just not really able to think clearly and speak and make your intentions known, then they can turn to your agent who will make those decisions. And within that document, you can specifically state what treatments you want to authorize, what treatments you don't want your agent to be able to make for you or to authorize for you. And along with that, healthcare power of attorney goes your living will. Sometimes they're the same document, and sometimes they're separate documents. And the living will, of course, is where you state whether or not you want life-saving measures to be taken on your behalf if you're not able to make those decisions. Let's not forget the Terry Chavo case from 20 some years ago. We all remember Terry Chavo, and for those of you who don't, she was separated from her husband. She became unconscious, was hooked up to life support. Her husband, she didn't have a healthcare power of attorney or living will in place. Her husband argued that she had told him that she did not want to be hooked up to life support. Her parents, of course, on the other side were saying, no, 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 we know our daughter. She would want everything taken, every last measure taken on her behalf. And what ended up happening is that they engaged in a very lengthy court battle over whether or not Terry Chavo should be disconnected from life support. The husband would win, then the parents would appeal, then the husband would appeal. And this just went on, and poor Terry Chavo just lay in that hospital bed hooked up to that ventilator on here. And you don't want that to happen to you. One, you want to make sure that your wishes are carried out, but you also don't want your family members to have to go through that kind of grief and expense, because the only people that won in that lengthy lawsuit was the attorneys. Don't let that happen to you guys. So make sure that when you go in to, see an attorney, don't just get your will done. Spend a little bit of extra money and get your healthcare and durable power of attorney and living will documents done as well. You need to have a complete estate plan. So hopefully you guys enjoyed it. There's a lot more estate planning mistakes that I could cover, but I just wanted to highlight some of the biggies that I see. Make sure if you like this presentation or you want more information that you follow us on social media. I've got listed our contact information there. I will be sending out a copy of this video to you all later. She'll have this. And I do thank you all for your attention. Hopefully you learned something. I'm going to stop the share and see if we have any questions from the audience. Or if I didn't explain something well enough, I'm going to stop the recording. Let me do that. Stop the recording.